Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzelli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by DocketWise, an all-in-one immigration forms and case management solution trusted by thousands of immigration lawyers across the U.S. I really like DocketWise. It makes immigration applications easy by allowing the clients to provide information through simple online questionnaires that are shareable by text or email and available in multiple languages. Not only that, DocketWise provides a comprehensive group of case management features, including invoicing and calendaring, secure messaging, task management, and a lot more. You can learn all about DocketWise and receive a 10% discount on your subscription by heading to docketwise.com/immigration-review, so they know we sent you. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. Hello, everybody. If you haven't seen it already on LinkedIn or elsewhere, Kurzban, Tetzelli & Pratt is hiring. We're hiring an in-person associate in our Miami office. Shoot me an email if you're interested. Not only that, and this is right hot off the press, KKTP is expanding. We're opening an office in Washington, D.C. From our public notice quote, the firm welcomes its new Washington-based partners, Carl Risch and Lauren Epstein. Mr. Risch is the Washington, D.C. managing partner and brings over 2 decades of experience in immigration law and policy in both the public and private sectors. He was unanimously confirmed by the Senate in 2017 to serve as Assistant Secretary of State for Consular Affairs, where he managed the worldwide visa and passport function for the United States government. End quote. He's done a lot of things. Welcome, Mr. Risch. He's joined by new partner Lauren Epstein, an immigration attorney who has represented individuals, families, and companies with their U.S. immigration matters for a decade. She is very experienced as well, and we are so happy to have her. Ira's thrilled too. And if Ira's thrilled, well, you know that it's cause for celebration. Enough of that. This was a very heady week of cases, even if there were only 4. All of the crimes at issue this week. Dust your thinking caps off and put them on. It's time to think. Starting off with Huynh v. Garland, published by the 8th Circuit on May 28th, 2024. Kicking it off with the 8th because we never do, and it just felt appropriate this week. And it's about crimmigration. This case, like the big non-citizen-friendly decision last week, is about the aggravated felony sexual abuse of a minor provision at INA Section 101A43A. These don't happen often with this ag-fel provision, and certainly not in back-to-back weeks. But here we go. Mr. Huynh is from Vietnam and was admitted to the United States as a lawful permanent resident in 2017. But less than 5 years later, he was convicted in Iowa of, quote, knowingly purchasing or possessing a visual depiction of a minor engaging in a prohibited sexual act or in the simulation of a prohibited sexual act in violation of Iowa Code Section 728.12.3, end quote. The less than 5 years thing is important because a single crime involving moral turpitude committed within 5 years of receiving your green card, essentially, will make a non-citizen removable. Not only that, but there is actually a specific aggravated felony for offenses, quote, described in 18 U.S.C. Section 2252 relating to child pornography, end quote. That's the never used provision at INA Section 11843I. But DHS didn't bring that charge here, perhaps under a belief that the aggravated felony provision only applies to expressly Section 2252 offenses rather than state offenses like it? Who knows? And I certainly am not sure because, again, the ag fel is never brought. DHS did, however, bring the sexual abuse of a minor aggravated felony charge of removability. And, well, the Iowa state offense is not one, said the Eighth Circuit. The categorical approach applies, and the least culpable conduct criminalized by this Iowa offense is knowingly possessing a visual image of someone under 18 years old engaging in a prohibited sexual act. But as the Eighth Circuit reads the statutes and dictionaries in effect in 1996, when the aggravated felony provision was passed so as to understand the generic federal definition of the sexual abuse of a minor statute, the Eighth Circuit believes that it was commonly understood that sexual abuse of a minor requires some sort of sexual act by the perpetrator against a child. Quote, none of these definitions captures simple possession of child pornography, end quote. Even the much maligned matter of Rodriguez-Arias decision from a split BIA all those years ago wouldn't go that far, said the Eighth Circuit, meaning that the generic definition of sexual abuse of a minor to the court does not include the mere possession of child pornography. Federal statutes and case law seem to, quote, require at least an act direct towards a minor, end quote, and mere possession of child pornography without production of child pornography doesn't cut it to the Eighth Circuit. After all that discussion, and like the 11th Circuit last week in its similar discussion, the 8th Circuit also reasoned that the placement of the sexual abuse of a minor phrase next to murder and rape at Section 11843A shows that Congress intended that aggravated felony to encompass, quote, only especially egregious felonies, end quote. A quote directly from the Supreme Court in Esquivel-Quintana, actually, and which of course is why the circuits rely on the argument. Quote, unlike sexual crimes performed upon or directed at a minor, simple possession of child pornography doesn't belong in the same subparagraph as murder and rape. To be sure, victims of child pornography suffer continuing and grievous harm as a result of their knowledge that a large, indeterminate number of individuals have viewed and will in the future view images of sexual abuse they endured. But Congress recognized this by dedicating a later subparagraph to such offenses, end quote. That's Section 11843L, that DHS didn't bring here, and I'm not positive could have brought. Meaning that the Iowa crime is not an aggravated felony. And DHS did indeed bring the charge that the conviction was a crime involving moral turpitude committed within 5 years of Mr. Huynh receiving LPR status, and you only need one ground of removability. Maybe it is, maybe it's not. Mr. Huynh argued to the BIA that it's not because it, quote, requires the defendant to have known only that he possessed an image, not that the image depicted a minor, end quote. Doesn't have a sufficiently culpable mens rea, Mr. Huynh argued. The BIA rejected this, however, because Mr. Huynh didn't provide, quote, examples of courts applying the Iowa statute to defendants who didn't know the person in the image was underage, end quote. But, well, that application of the realistic probability test by the BIA is so wrong in every circuit except the Fifth Circuit that, quote, the government does not defend the BIA's decision, nor could it. We do not require petitioners to prove through specific convictions that unambiguous laws really mean what they say, end quote. The text of an overbroad statute satisfies the realistic probability test or makes it inapplicable. Whatever route a circuit wants to take, it's the same result. The overbroad text of a statute makes it unnecessary to find a case exemplar everywhere except the Fifth Circuit. The Eighth Circuit is, however, giving the BIA another shot to determine whether the text of this statute permits conviction with a mental state less than that required of a CIMT. Seems like it doesn't, though. Congrats then to unnamed counsel for smart, successful arguments. And that is Huynh v. Garland. Next is Lopez-Sorto v. Garland, published by the Fourth Circuit on May 31st, 2024. This case is about Convention Against Torture protection. Mr. Lopez-Sorto is from El Salvador and was admitted to this country at 8 years old in 1982 as a lawful permanent resident. But he did not naturalize. Maybe he didn't naturalize because at 18 he joined the El Palo street gang and killed a rival gang member in 1995. He remained incarcerated for that murder until 2021. He's in his 50s now and he, quote, claims to have left gang life behind him, end quote. His gang disbanded anyway. Really just goes to show how ridiculous and tragic gang loyalty is, especially for a young person. But then again, I've never lived under those circumstances. He was transferred directly to ICE custody for removal proceedings where, due to his conviction, only cat deferral was on the table. He fears the Salvadoran authorities, anti-gang death squads in that country, MS-13, and Mara-18 due to his past gang affiliation and tattoos. An immigration judge and then the BIA denied, and the Fourth Circuit here affirmed. And actually, ICE deported him during the petition for review, so Mr. Lopez-Sorto is currently in El Salvador. As such, first, and after flirting with it and actually going pretty deep into the issue, the Fourth Circuit held that the matter isn't moot just because ICE itself removed Mr. Lopez-Sorto during this litigation. And that's because of ICE's own directive, which instructs ICE to generally return non-citizens like this if they succeed on their petition for review, quote, absent extraordinary circumstances, end quote. The analysis got really text-specific of that ICE directive, and the panel came close to finding this petition for review, which is only about cat deferral, moot. Plus, I suppose ICE could one day revoke its directive, right? Not only that, the Fourth Circuit used a lot of non-citizen adverse dicta to get to the non-mootness finding, that, who knows, may appear in a future decision on another issue. But for our purposes, the matter's not moot. In line with the ICE directive, if nothing else, Mr. Lopez-Sorto's presence would be necessary to complete the remanded removal proceedings if he succeeded right now before the First Circuit in challenging the denial of cat deferral. But removal proceedings will not be remanded as the Fourth Circuit upheld the denial of cat deferral. Not for nothing, because of the Supreme Court's Nasrallah decision, the Fourth Circuit can review the facts underlying the cat claim for substantial evidence, notwithstanding Mr. Lopez-Sorto's serious criminal conviction. And, quote, when a cat claimant asserts that he faces multiple potential sources of torture, he is entitled to protection, so long as the aggregate risk of torture that he faces is above 50%, even if the risk stemming from any individual source falls below that threshold, end quote. The court believed it adequately considered here. A lot of it comes down to matter of JFF, the case that requires that cat applicants show that every link in the hypothetical chain of torture is more likely than not to occur. Quote, that a chain of dependent events leading to a deportee's torture is no stronger than its weakest link is simple mathematical truth, end quote. So the panel here is for the IJ and the BIA relying on matter of JFF to deny a cat claim. Before I went any further in this decision, something was bothering me about that, so I went back to my notes. And wouldn't you know it, at the end of Santos Garcia v. Garland from episode 168, out of none other than the Fourth Circuit, I said this, quote, from a footnote of course. For all of you litigating in the cat space who hate matter of JFF, the Fourth Circuit held in the 2019 pre-podcast decision, Rodriguez-Arias v. Whitaker, that cat applicants are not in fact, quote, and now this is the court, required to establish a specific chain of events leading to his torture, end quote. So that's what I said like 50 weeks ago. So what about that, Fourth Circuit? And very smart counsel made that exact argument next, that both of these cases implicitly abrogated matter of JFF in the Fourth Circuit. How can that not be the case? Well, notwithstanding the very clear quote I just read, the Fourth Circuit reads Rodriguez-Arias narrowly to only being about circumstances where the non-citizen fears torture from several sources. In such cases, it seems that the JFF analysis is not appropriate. To be honest, it seems like this panel very much likes matter of JFF and has decided to save it as much as Fourth Circuit precedent allows it to do. And there are multiple sources of feared torture here, right? And so where, like here, there are multiple sources of feared torture, a quote, court must first determine the likelihood of torture by each entity, then combine each likelihood together to determine whether, in the aggregate, the non-citizen has shown he's more likely than not to be tortured, end quote. In such cases, the JFF, quote, chain of events analysis couldn't be used on that first step, end quote. Okay, not gonna lie, I'm a little confused. Here's what I think the court is saying. Here, explained the Fourth Circuit, the IJ did what this panel believes its case law permits. The IJ first considered all sources of potential torture together. And importantly then, the IJ didn't believe it likely that Mr. Lopez-Sorto would be tortured by Salvadoran authorities or death squads. the first two of three reasons. And so then, the IJ applied matter of JFF to the last reason, the single remaining source, the street gang fear. The IJ believed then that that was just a series of suppositions that were barred by matter of JFF and then denied cat protection. Quote, so the IJ properly looked to the likelihood of a chain of events as to a single alleged source of torture. He did not require proof of a specific chain of events whole cloth. End quote. I guess? Because the IJ categorically simply rejected the first two out of three potential torture sources? You tell me, Fourth Circuit practitioners. So too, the IJ properly discussed all alleged sources of torture. The IJ discussed it and said that everything was being analyzed in the aggregate. This made it unlike Rodriguez-Arias again to the Fourth Circuit panel, where the IJ there neglected a possible torture factor. So too with the BIA's decision. Nor did the IJ err in ignoring expert testimony, explained the Fourth Circuit. Or that is to say, the Fourth Circuit believes that the IJ and the BIA consider the expert witness testimony sufficiently. For example, quote, the IJ decided to give greater weight to their testimony that Mr. Lopez-Sorto would not likely be a target for recruitment, and their failure to identify a similarly situated person who has been tortured in El Salvador, end quote. So there you go. A decision that was published likely in an effort to narrow Rodriguez-Arias in the Fourth Circuit. And that is Lopez-Sorto v. Garland. Moving on to Stankiewicz v. Garland, published by the Second Circuit on May 31st, 2024. The Second Circuit hit us with two big and important non-citizen-friendly decisions on Friday. This first one is about controlled substance offenses. And if you think this one gets into the weeds, just wait for the next one. Miss Stankiewicz is from Poland and became a lawful permanent resident in 1992 at age 11. She didn't naturalize and as a young adult was convicted for distributing a controlled substance on or near school property in violation of New Jersey Statute Section 2C:35-7. Conviction documents show that the substance was cocaine. 15 years later, during the last administration, DHS sought to remove her. DHS alleged that the conviction not only made her removable because it related to a controlled substance, INA Section 237A2BI, but that it was also an aggravated felony for a controlled substance trafficking offense, INA Section 11843B. Of importance, if the conviction is an aggravated felony, it not only makes Ms. Stankiewicz removable, but precludes her from asking an IJ for grace and seeking LPR cancellation of removal, notwithstanding her long-term residence in this country. Ms. Stankiewicz initially conceded the charge, but later asked for a continuance to see what the Third Circuit would do with the BIA's precedential decision in the matter of Rosa, on direct petition for review. The immigration judge denied all that and ordered her removed. But wouldn't you know it, during the BIA appeal, the Third Circuit vacated matter of Rosa on direct petition for review. Pretty important here because matter of Rosa involved the exact same New Jersey conviction. And the Third Circuit held that the conviction, quote, is an aggravated felony only if it categorically matches the most similar federal analog, namely 21 U.S.C. Section 860, the federal school zone statute, end quote. The BIA's decision, in contrast, had held that the New Jersey offense was an aggravated felony at 101A43B because it matched a federal crime at 21 U.S.C. Section 841, a federal controlled substance distribution statute. But the Third Circuit said that wasn't the proper analysis. The BIA was looking to the wrong federal analog. Confusing stuff. Now this case is all happening in an immigration court in the Second Circuit, but the IJ did rely on matter of Rosa, which counsel argued to the BIA, quote, no longer had any legal force, end quote. The BIA didn't agree, an issue that I've been very vocal about on this podcast and which I truly do not understand, and so long story short, it's now all before the Second Circuit, which vacated the BIA's removal order. And man, would I have loved for the Second Circuit to explain whether it believes matter of Rosa has legal force or not anywhere, or that rather, whether it's zombie precedent vacated on direct petition for review by the Third Circuit that therefore can't bind any IJ anywhere. But the Second Circuit did not address that issue, one way or the other. They never do. Why? Why? The categorical approach applies to the aggravated felony drug trafficking analysis. This is a very complicated case with complicated statutory analysis, and with the big boy coming up after it, I'm going to try to do it quicker than a deep dive would require, but still, lots of analysis. The text of INA section 11843B is important here. It makes a conviction an aggravated felony if it is for, quote, illicit trafficking in a controlled substance, including a drug trafficking crime as defined in section 924C of Title 18, end quote. That's federal criminal law, and section 924C in turn refers to, quote, any felony punishable under the Controlled Substances Act, end quote. To the Second Circuit, and I believe BIA and Third Circuit before it, that means that the New Jersey offense is only an aggravated felony if it matches a felony punishable under the CSA. And a felony under the CSA also must require a maximum term of imprisonment over 1 year. Pretty broad range of CSA felonies to choose from then, particularly as here, the Second Circuit doesn't believe that the corresponding CSA felony must be, quote, the closest one to the state statute of conviction, end quote. It just must be a federal CSA felony, the elements of which must match all of the elements of the state offense. That whole thing, whether the generic comparing statute must be the closest type of federal crime, is a whole issue in and of itself and kind of conflicts with what the Third Circuit held, but I'm going to just skip it here. To the Second Circuit, the whole world of CSA felonies is at play for a possible match to the New Jersey offense to therefore make it a drug trafficking aggravated felony at INA section 11843B. Again, the Third Circuit in its Rosa decision believed that 21 U.S.C. section 860 was the most relevant statute of comparison, which apparently is a CSA felony and does involve drug trafficking around schools. Maybe so, maybe not, said the Second Circuit, but regardless, the New Jersey offense criminalizes conduct broader than section 860. Specifically, the New Jersey offense criminalizes dispensing a controlled substance, while section 860 does not, and the New Jersey offense criminalizes conduct on a school bus, while section 860 does not. The state crime is broader than the federal corollary that the Third Circuit believed applicable, and that was argued here. Saying nothing, by the way, about whether or not New Jersey criminalizes more substances than does the federal CSA. Turning then to 21 U.S.C. section 841, the statute that the BIA believed was the appropriate federal corollary and point of comparison in matter of Rosa, and which the Third Circuit disagreed with when it vacated matter of Rosa. Maybe so, maybe not, said the Second Circuit. But section 841 as well does not match the New Jersey statute, regardless of whether it is the appropriate point of comparison. Now this is just me, but the proposed federal corollary, section 841, doesn't have anything to do with schools whatsoever. The Second Circuit has already determined in this decision that that's not necessarily dispositive, but also the New Jersey statute criminalizes even more than this general federal drug trafficking statute, section 841. That federal statute excludes, for example, distributing a small amount of marijuana, and the Third Circuit has held that a small amount of marijuana that's excluded equates to an ounce or less. The New Jersey statute, in turn, expressly includes less than an ounce of marijuana. Really trying to criminalize conduct, even if it doesn't involve that much marijuana, because it's happening around minors and schools. But that means that it criminalizes more conduct than does section 841, perhaps, again, because section 841 isn't concerned with conduct around schools at all. Pretty straightforward, actually, then. The New Jersey statute is broader than both of the federal analogs proposed. That ends the aggravated felony inquiry, unless the statute is divisible, the New Jersey one that is, but it's not. Lots of discussion here as well, but the New Jersey crime clearly lists all of the things that it criminalizes in one crime. The statute doesn't make the different way to do all of the things elements, or the different controlled substances at issue elements, nor need a New Jersey prosecutor prove the specific way that a defendant committed a crime. This held the Second Circuit despite the fact that, quote, someone who sells multiple drugs in a single transaction can be found guilty of multiple section 2C-35-7 counts, end quote. That is, there aren't double jeopardy concerns, it seems, something that the BIA has recently stated strongly indicates divisibility. And here's a huge quote for all of you. Quote, "It does not follow that just because the government can bring multiple charges based on a single transaction involving more than one controlled substance, that drug type is a required element of a conviction." End quote. Emphasis by the court. And that's a huge quote for all of your drug cases. It also involves a nice hypothetical explanation for why to use with your similar statutes. Rejecting other arguments that the government was throwing at it, such as taking a Mathis peek, the Second Circuit expressly held that, quote, Section 2C:35-7 is indivisible, end quote. Heck, even the fact that the jury instructions have a blank space for the jury to fill in the drug don't make the drug an element, said the Second Circuit. Quote, "The instructions do not say it is impermissible to identify more than one substance," end quote. No, they do not. It's a very complicated case, but it's also a must-read on Section 101A43B aggravated felonies and divisibility for drug statutes both within the Second Circuit and everywhere else, really. Huge case. As such, congratulations Joshua E. Bar-David and Thomas V. Masucci for petitioner. What do you think, New Jersey Crim Im Attorney Extraordinaire Lauren Anselwitz? And that is Stankiewicz v. Garland. Say goodbye to missed calls and wasted time on unqualified consultations. With Staffy Live, you get a dedicated team of truly bilingual and highly empathetic specialists answering the phones for your immigration law firm 24/7. Staffy Live specialists go beyond just answering calls. They qualify callers by asking the right questions, ensuring that only qualified consultations make it into your calendar. Plus, they don't stop there. Staffy Live can also handle follow-ups, so you can focus on what you do best, practicing law. Staffy Live is a service for immigration law firms only. And here's the best part. You can try Staffy Live absolutely free for 15 days, no strings attached. Just visit www.staffy.cc, that's stafi.cc, and click Get Started. Of course, use the code FREE to claim your free trial, or click on the links in the show notes. We all know the immense dedication it takes to be an immigration lawyer. You fight tirelessly for your clients, their families, and their futures, but let's face it, the administrative side of running a practice can feel overwhelming. Mountains of paperwork, endless calls, juggling deadlines, it can easily steal your focus and leave you feeling burnt out. But what if there was a way to simplify all of it? I want to tell you about FileVine, a legal case management platform specifically designed by lawyers for lawyers. FileVine keeps all case information centralized in one place. Plus, FileVine's immigration-specific tool, Immigration AI, uses the most advanced AI-powered technology to extract vital information from passports, birth certificates, and other essential documents, and automates U.S.C form filling through smart questionnaires available in up to 170 languages. Pretty impressive. FileVine and Immigration AI can give you back precious time and energy, allowing you to focus on what matters most, your clients and their cases. So if you're ready to reclaim your time and rediscover the joy of practicing immigration law, head on over to immigration.ai/immigration review. Links in the show notes. Which brings us to Black v. Decker, published by the Second Circuit on May 31st, 2024. Not Black and Decker, although technically it is Black and Decker, and another petitioner as well, suing repeat podcast appearing respondent Thomas Decker, the head of the New York ICE field office, for the allegedly unlawful detention at issue here. And they won. I'm going to just come out and say it. It's a welcome and somewhat counter decision to the big bad decision out of the Fourth Circuit 2.5 months ago in Vasquez-Castaneda v. Perry from episode 203. Although that decision was in the withholding of removal context and was so post-final order of removal. This case, in turn, is about mandatory detention pre-order of removal during removal proceedings under INA Section 236C. And here's what's going on. The two petitioners are lawful permanent residents who the U.S. government detained without a bond hearing pursuant to INA Section 236C. Quite the remarkable statute, that one. Both LPRs had served their criminal sentences many years in the past, and yet, under Congress's statute, were subject to a second immigration imprisonment after they served their sentence without even the opportunity for an immigration judge to determine whether indeed they were still a danger to the community or a flight risk, even though they had, after all, served their criminal sentences. In their cases, many years ago. That's INA Section 236C. Now, the U.S. Supreme Court has already held that the statute's text cannot be read in such a way as to mandate a bond hearing. That's most recently the Supreme Court's Jennings decision. So now, either prolonged detention of non-citizens without bond hearings is constitutional or it's not. That case will surely be heard by the Supreme Court within the next few years. Jennings itself is currently on remand to a district court in the Central District of California, I believe. These petitioners sat in immigration for 7 and 21 months, respectively, before filing habeas actions demanding simply a bond hearing from a neutral arbitrator. The first petitioner, Mr. Black, succeeded before the district court. The second, Mr. GM, who I believe is also seeking cat protection, did not, despite his 21-month detention. The Second Circuit here resolved this district court split for Mr. Black and non-citizens everywhere in the Second Circuit. Quote, "A non-citizen's constitutional right to due process precludes his unreasonably prolonged detention under Section 236C without a bond hearing. We further decide that Matthews v. Eldridge supplies the proper framework for determining when and what additional procedural protections are due such a detainee." End quote. Big holding, and it conflicts with Vasquez-Castaneda, which held that Matthews doesn't apply in the prolonged detention context. Good enough for me. Even though, of course, Vasquez-Castaneda is in a different context. And this despite, as of the time of this writing, both Mr. Black and Mr. GM have been ordered removed and have BIA appeals pending, and both were actually eventually released from detention for various reasons. But here we are. First, these claims are not moot, I believe, because ICE might choose to detain them again, I believe. On to the merits. It's true that Section 236C mandates detention pending a decision on removal for lots and lots of non-citizens, including those convicted of aggravated felonies or other specified immigration offenses. Sometimes even a conviction is not necessary to take away liberty without even a bond hearing. In immigration, of course. But to the Second Circuit, the earlier Supreme Court decision in, quote, Demore and Jennings leave open the question whether prolonged detention under Section 236C without a bond hearing will at some point violate an individual detainee's due process rights, end quote. So does it? The Ninth Circuit hasn't said yet on remand from the Supreme Court, but the Third Circuit actually addressed the issue in German Santos v. Warden Pike County from 2020, which I could have sworn I did, but maybe only did at the top of an episode. In that case, the Third Circuit held that prolonged detention could require a bond hearing. Seems like the Second Circuit might have gone even a little farther than German Santos. First, the Second Circuit held that indeed prolonged detention without a bond hearing under INA Section 236C, while it might be what the statute requires, is unconstitutional and in violation of the Fifth Amendment Due Process Clause. That's in part thanks to dicta from the Supreme Court's 2001 post-removal order detention decision in Zadvidis, but also non-citizens have constitutional rights too. Quote, "The Constitution does not permit the executive to detain a non-citizen for an unreasonably prolonged period under Section 236C without a bond hearing. At some point, additional procedural protections, like a bond hearing, become necessary." End quote. Also, not for nothing, in a footnote, the Second Circuit says what immigration attorneys everywhere already know. When the government told the Supreme Court in Zadvidis, and the Supreme Court relied in Zadvidis on the belief that, quote, "removal proceedings are completed in an average time of 47 days and a median of 30 days, end quote, in the detained context, well, that was not correct. The acting Solicitor General admitted as much to the Supreme Court in 2016. Anyway, this all follows the Second Circuit's technically vacated decision in Shanahan v. Laura, and that totally not vacated and very non-citizen-friendly decision in Velasco-Lopez v. Decker from episode 27 that was in the INA Section 236A detention, non-mandatory context. Indeed, reasoned the second, even though Velasco-Lopez wasn't about mandatory detention, it's the same Constitution, meaning the same constitutional rights and concerns for non-citizens when detention becomes prolonged. Second Circuit district courts have been a bit all over the place on this, which isn't surprising, but now that's over. So what exactly is required? Well, like in Velasco-Lopez, it's the well-known 50-year-old due process test from Mathis v. Eldridge. Oil's been fighting this very hard. But multiple circuits have applied Mathis in the immigration context, including even the Fourth Circuit, as well as the Ninth, First, and Third Circuit, and likely others. Lots of very good arguments for why Mathis should apply. By the way, if you're making this detention argument in any circuit that hasn't reached this specific issue yet, which actually is every court except the Third Circuit. Although good luck on the Fourth. But when does it apply? Well, although the Second Circuit declines to adopt a bright-line rule, quote, de morens advertis imply, we agree, that any immigration detention exceeding 6 months without a bond hearing raises serious due process concerns, end quote. Still, it's a case-by-case application of Mathis that determines when, even before 6 months, I guess, due process has become unconstitutionally prolonged such that a bond hearing must be held. So, Mathis, as a refresher, it requires consideration of 1. The private interest that will be affected by the official action, here detention. 2. The risk of an erroneous deprivation of such interest through the procedures used and the probable value, if any, of additional or substitute procedural safeguards. And 3. The government's interest, including the function involved in the fiscal and administrative burdens that the additional or substitute procedural requirement would entail. You can see why non-citizen advocates are advocating for application of the Mathis test in the non-citizen detention context. Because in this case, and like all similar cases, quote, the private interest affected by the official action is the most significant liberty interest there is, the interest in being free from imprisonment, end quote. Going to weigh heavily for the non-citizen most times. Liberty is the norm in the United States, explained the Second Circuit. Particularly as, which is pretty much always the case, the non-citizens had already served their criminal sentence. Not only that, but the private interests of the non-citizens here were simply devastated, financially, due to their detention. As was Mr. GM's health a bit during the COVID-19 pandemic where he was detained, and that was at the time killing non-citizens and prison guards, before ICE relented and started releasing people in response to the Freyhat litigation. Remember that, everybody? Nor is there an administrative mechanism available to challenge their detention. The Second Circuit did not discuss the regulatory periodic ICE reviews that ICE claims that it does and which the Fourth Circuit relied on in Velazquez-Castaneda. Although as this is mandatory detention, perhaps they don't happen in the Section 236C context? If they do, well, the Second Circuit doesn't believe them relevant or actually reasonable protections against erroneous detention, which makes sense, as ICE's role is to be the enforcement agency and the prosecutor rather than the neutral arbitrator. In any event, quote, here, the almost non-existent procedural protections in place for Section 236C detainees markedly increased the risk of an erroneous deprivation of petitioners' private liberty interests, end quote. The Second Circuit doesn't love using whether a conviction matches a removable offense as a proxy or conduit for dangerousness anyway, it seems, believing it a, quote, poor proxy, end quote, as did Justice Breyer, by the way. In fact, and this is simply staggering and should give us all pause, quote, before Jennings vacated Laura in 2018, data showed that 62% of Section 236C detainees given bond hearings under Laura were released, confirming the absence in many cases of a sound justification for detention, end quote. Similar statistics from the First Circuit too, and probably from all the circuits before their precedent was overturned by the Supreme Court in Jennings. Finally then, the government's interest. Yes, the government has a legit interest to ensure that non-citizens appear at their hearings and protect the public. But like That's what a neutral arbitrator bond hearing before an immigration judge is for, right? Said the Second Circuit. So the government has not articulated any justifiable interest, said the court, which would appear to be always the case then, notwithstanding the case-by-case analysis required of Mathis, says I. Not to mention it's very expensive to detain non-citizens. So, a hearing is required when detention has become unconstitutionally prolonged. Which brings us to my favorite legal concept, former law clerk that I am, who bears the burden of proof at the bond hearing? So important. And it's ICE, said the Second Circuit. Quote, the burden at the bond hearing is on the government to justify by clear and convincing evidence that the non-citizen poses a risk of flight or a danger to the community, end quote. Not only that, but the IJ, quote, must consider the non-citizen's ability to pay and the availability of alternative means of assuring his appearance, end quote. So, ordering ankle bracelets or ICE check-ins in lieu of very high bonds? It's the government, after all, reasoned the court, that is seeking to deprive liberty. Plus, statistics show how important having immigration counsel is in removal proceedings, and how much more difficult it is to get an attorney and to work with an attorney when detained, particularly as statistics show how often ICE transfers non-citizens all over the country when they are detained. Also justifying a burden upon ICE during these bond hearings, and I just love this, quote, as the First Circuit observed, proving a negative, especially a lack of danger, can often be more difficult than proving a cause for concern, end quote. How does one prove a negative, like not being dangerous? If nothing else, it risks erroneous deprivation of the all-important constitutional liberty interest, something the Supreme Court has regularly recognized in the non-immigration criminal detention context. Explain the court. Again, gotta consider the non-citizen's financial means and alternatives to detention too, even for those with some flight risk. Quote, refusing to consider ability to pay an alternative means of assuring appearance creates a serious risk that the non-citizen will erroneously be deprived of the right to liberty purely for financial reasons, end quote. And that's not constitutional. Huge stuff. And so, congratulations, Adeyo Adowo for Mr. Black, Amy Belsha and a whole team from ACLU New York on amicus, Julie Donna and a whole team from the Legal Aid Society New York for Mr. GM, as well as a bunch of students from Cornell Law School. Big, important non-citizen win. Before we conclude the case and the episode, you know I'm not one to skip humanizing these cases. It's just such a long decision. But if you're curious, Mr. Black is from Jamaica, received LPR status at 21 years old in 1983, and he's lived here for 40 years. He lives with his wife and his stepdaughter. He is the sole provider for his family, and he owns a home where he lives and which was purchased with his earnings. He has a known address. He was detained during the prior administration without a bond hearing and had removal proceedings initiated against him due to a sexual abuse and a child abuse conviction from 20 years prior, for which he had served no jail time and never violated probation. All of that highlighted his non-danger and the risk of erroneous detention to the Second Circuit. Similar with Mr. GM, although not quite as long a time between his crime and his removal proceedings. He's from the Dominican Republic, and he's been here since 1988. He's been an LPR since 2011. A fight in a restaurant in New York City in 2012 led to a second-degree assault conviction and 2 years imprisonment with early release on parole. He lives with his mother and assists her medical needs. Same thing, removal proceedings and detention under the prior administration, and well after his conviction concluded. And that is Black v. Decker. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/immigration review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview, that's IMM Review. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.